10-25-2-46808 Anderson v. Long.
Hello again.
Hello. Good afternoon, Mr. Fry.
Good afternoon.
And I've already confirmed this is not the Meredith Long that I initially assumed it was. So what I think I have in front of me is a motion hearing to dismiss the amended counterclaim and or provide a more definite statement.
Yes, that's right.
Okay. Give me just a second to switch out of the last case and I will be ready for you here in a second. All right, Mr. Jackson, go ahead. I do have those documents pulled up.
Thank you. So this is a motion to dismiss or for a better statement, the alternative. This motion relates to the causes of action, so the claims. I don't take into issue the facts in defendant's counterclaims, merely the claims. And so of course, case law, we're a notice pleading state. And what that means is we need to have a statement of the claims. A litigant must plead more than general facts. They have to plead their causes of action. And of course, the obvious reason for that, if you don't plead your cause of action, then what are we fighting over? What are the claims? What are the elements of each cause of action? Those can't just come as a surprise at trial or any time in this case. They have to be enumerated in a complaint or counterclaim. When we look at defendant's amended counterclaim, they list out, I'm starting at page 5, there's a paragraph titled B, quiet title ejectment. And of course, there's a claim for quiet title that exists in the world, and then there's the cause of action called ejectment, having it listed together, and the nature of the relief requested make it confusing to understand. Are we talking about 1, quiet title, 2, ejectment, or one thing called quiet title ejectment? What is this claim? If we go to plaintiff's response, it says quiet title. And so it makes me wonder, do we have an ejectment claim here? Is that part of, these causes of action that we can list out? And so next, paragraph C, a paragraph titled interference with driveway easement. There's not a cause of action recognized by Washington case law that I can find titled interference with driveway easement. Now, of course, if you go interfering with somebody's driveway easement, that can lead to other causes of action, right? Quiet title, permanent injunction, but that's not what's listed here. What's listed is interference with driveway easement, which makes me confused as to what I'm defending against. And what are the elements, for example? If there's no case law talking about interference with driveway easement, what are the elements? And I can't say what they are. And then going to defendant's response to paragraph C, defendant seems to imply that paragraph C is just a declaratory relief cause of action. Well, okay, Washington courts do recognize declaratory relief, but why are they not calling it declaratory relief? Where would I know from their amended complaint that I'm dealing with declaratory relief? Of course, there's a whole body of case law around declaratory relief, and I could prepare for that. I could, if we're gearing up for a trial and I'm preparing, I could know that. But as it's written, I don't know that declaratory relief is a cause of action. Paragraph D, interference with privacy and nuisance. That sounds like 2 independent claims for me. They're listed under the same paragraph, so it makes me wonder, do we have 1? Do we have 2? Defendant's response seems to say, well, we have 2. We have interference with privacy and we have nuisance. And Judge, I'm sure you can see where this is confusing. If we read through this counterclaim and we ask the question, 1, what's the quantity of claims being brought here? And what are they? Can we just make a simple list? 1, quiet title, 2, ejectment, 3, interference with driveway easement. Is that on the list? What's on the list? That's what my motion says, is I need to know the specific causes of action so I know which elements to be gearing up to defend against. Right now, I don't have that. And the case law cited by defendant, I'm reading from page 5 of the defendant's response. The only issue before the trial judge is whether it can be said there is no state of facts which plaintiff could have proven entitling him to relief under his claim. And so the defendant seems to be making this about a factual issue. It's not a factual issue. The defendant's own case law says you need to have a statement of facts entitled to you relief under your claim. What's your claim, defendant? That's what I want enumerated. And so Judge, if a reading of this doesn't tell the reader exactly what claims there are, help me number them. What are they? Help me title them. What are they? If you can't get that from a reading of this counterclaim, it should be dismissed, or give me a more definite statement of the alternative. That's all.
Understood. Thank you. Mr. Fry, go ahead.
Your Honor, this is a liberal construction of pleading state. I've never had this issue come up before except with a pro se litigant. The statute is for quiet title and ejectment. If you read the case law, our courts don't number the claims. I don't know what counsel's talking about other than wasting this court's time. He has plenty of notice. This is a simple case, Your Honor. We have a survey. They're violating the survey. They don't like the survey. Do they have another survey? No, they have nothing. They have no evidence. And so instead, they're going to play these motion games with us. I need to do discovery. I'm waiting for them to answer. Can counsel simply deny the facts or can he admit them? Apparently not. Apparently he has no idea what those facts mean.
Okay,
and
well,
it's
Mr. Fry, let's take down the temperature a little bit.
Well, my clients are paying a lot of money right now. And what's happening is this lawsuit just got filed with the survey this year. We have a new survey coming in, and I'm going to need to amend my complaint again because I think we have some additional claims now to add against Mr. Jackson's clients. Additionally, we're finding more witnesses and evidence of harassment. I have a long list of emails, harassing and intimidating emails sent by Mr. Jackson to my office, making a serial list of demands, not based in law or fact, just based on, we're going to sue you. We're going to file motions. Well, here we are, Your Honor.
Okay, Mr. Fry, hold tight. Well, let me ask you this. When I look at B in your July 1st amended answer, it does list under counterclaims one phrase, and it says quiet title ejectment. Those are, as you well know, I'm not telling you anything you don't know, those are two separate causes of action. So could those be more clear so that Mr. Jackson does know what the counterclaims are?
Are you giving me stylistic points, or are we going to go by substantial justice to review the pleadings for substantial justice? Substance over form. This is the rule.
Mr. Fry, what I am telling you, I am not giving you I'm not giving you any suggestions. I'm asking a question. I have never heard of a cause of action called quiet title ejectment. So what do
you have not? It's the same statute, Your Honor.
There is nothing called quiet title ejectment. Those are two separate.
If you read the facts, Your Honor, we have a survey. We want the survey recognized. That's quiet title.
Correct. It's not quiet title ejectment.
If the individual's over the property line, they need to be ejected. Those facts are set out. You've already concluded.
Right. So, Mr. Fry, you are asking for quiet title
and ejectment.
And ejectment.
And a lot of
okay, I am going to ask for that to be made more definite because you have it listed as one counterclaim called quiet title.
And what rule requires me to individually identify these?
Mr. Fry, I'm not going to argue with you. My ruling is that your counterclaim is listed as quiet title ejectment. I am making it. Hold on, Mr. Fry. I am making a finding that there is no such thing as quiet title ejectment, and I am asking that you answer with a more definite statement as to quiet title and ejectment.
Would you allow me to add an article to quiet title and ejectment, or is the ruling that I cannot say quiet title ejectment?
I'm asking for a more definite statement as to both quiet title and ejectment.
Okay, for the record, this is prejudicial against the defendants because we are unable to conduct meaningful discovery pending this motion and the court's ruling. We will proceed and provide another amended counterclaim. It's going to be a third amended counterclaim. I will put numbers on everything I can think of, Your Honor. I hope that leads us to a discovery phase where we can actually find out if counsel has a survey to back him up. So I can do that within 1 week.
Okay. Mr. Jackson, will that work for you? If
Yes.
you give a more definite statement as to all counterclaims alleged within 1 week.
Yes, and I think in these circumstances, it's good to set clear expectations. Counterclaims can be counted like anything else, right? There's a number of them. 1, 2, 5.
We're going to count everything.
Mr. Frey, hold on. Hey, guys, stop. I'm not asking, you've never heard me say I want numbers. I just want causes of action to be called what they are supposed to be called. So if it is quiet title, it is quiet title. If it is ejectment, it is ejectment. Okay? If it's nuisance, it's nuisance.
Your Honor, I cited RCW 7.28, ejectment quiet title. That's the name of the statute. There's no and there's no numbers. So I'm perplexed on what else.
There is a comma. I'm looking at it with you. It is ejectment, comma, quiet title.
So I need to add a comma.
No, they are two separate causes of action. That RCW deals with both ejectment and quiet title. So I'm asking for a more definite statement as to both quiet title and ejectment. I don't care about numbers. I really don't care about numbers. I just care about everyone getting notice as to what is being asked for.
It's a quiet title ejectment case, Your Honor.
Those two causes of action are one.
Doesn't matter when I'm asking for relief. It doesn't matter now. It's not going to matter during discovery. What matters is I need an answer. He needs to answer our counterclaim. That's what I'm asking for. I'll file a new one, put numbers on it. I'll put bullets on it or whatever he wants.
I'm glad to answer. I need to know what your counterclaims are.
You're going to find out.
Mr. Fry, let's take the temperature down here. My ruling will stand. It'll be due. The more definite statement to Mr. Jackson will be due in 1 week. And then if the parties need to note anything up further regarding discovery or further motions, you are welcome to do so.
All I got is I'm supposed to do a more definite statement.
As to your counterclaims, you've already told me you're amending to add new counterclaims, I believe. Is that correct?
Yes, we have the case is developing, Your Honor. I just got another survey yesterday that I sent to counsel today.
Okay.
So I don't know if you can rephrase your order so it's clear to me. All I got was there needs to be a division between quiet title and
Mr. Jackson, would you prepare an order in accordance with my ruling?
Yes, Judge.
Okay.
I think that's necessary because I am very confused right now, and it's very discouraging, Your Honor.
I'm getting close to the point of having you in person for the next hearing because I'm not really sure what's going on right now.
And this is getting contentious, but I would like to say I genuinely want to know each of your counterclaims. That's it. I want to know what they are.
What we're trying to do.
Great.
All right. I'll look forward to receiving the order. Anything else the parties need today?
When's the order? Do I have an idea when I'd get a copy of the order?
I'll try to email you today.
Yeah. Go ahead, Mr. Jackson.
Oh, I'll send you a draft of it today.
Would I be able to get a copy of the signed order once it's signed?
Absolutely.
Thank you.
All right. Anything else we need to do today?